The purpose of this video is to orient people on the CAASI group, as well as partners, about our process map for police investigation, which was developed by assessing at random union contracts for police departments, often known as FOPs. We will go ahead and step you through these different PowerPoint slides in understanding that these are just drafts of what could be much larger scaled system or processing maps. If you will notice at the top, there are 6 different phases. The phases are represented above. You have complaint, notification, investigation, conviction, ex post, which means past the fact of conviction, and then what happens to the actual records of the investigation and the conviction. So there are often many scenarios which can happen, but for the main purpose of the 6 different police union contracts that were investigated, there were 2 main scenarios that were mentioned. The first was that a citizen files the actual complaint, meaning the citizen felt that their rights had been violated or that they had at some point experienced a form of violence or human rights violation by a police officer, and they wish to form a file complaint. During this, there are actually conditions that need to be met for the actual investigation to take place, and these are known as the conditions to proceed. One of the conditions that must happen is that at any point, if a complaint is filed, it must be filed within the appropriate time frame of the alleged event. So, for example, if a cop pulls someone over and abuses them or pulls a gun on them or tases them, and the citizen felt that that was not warranted, they can file a complaint. However, there is what is called a limited time frame according to the police contract with the city. And often these time frames are measured in the indicator of months. For example, often it was mentioned about 6 months. So within the span of definitely less than a year of the alleged event, the citizen has to file a formal complaint. We have noticed that there are discrepancies about what information is actually collected from citizens. In some areas, citizens do not need to provide their signature or name. They can just file the complaint anonymously, and then it will become what's called internal investigation. However, in some areas, citizens actually have to provide all their information. This becomes an issue later. Once the complaint is actually filed, and this entire PowerPoint demonstrates when everything actually goes well. This is actually what happens when everything that should be done through the process is done cleanly and without any discrepancies that could be taken up by the actual representation or legal representation of the plaintiff. And what happens is, if the actual citizen filed complaint is done within the 6-month time frame, for example, what will happen next is that in the notification phase, first the bargaining member, or the BM, which is often what they're called, the policeman who is being accused, will be notified that they are under investigation, as well as anyone who is associated with them or may have been a witness. Within this, there is actually another set of conditions that must happen. And with the citizen filed complaints, this time frame, there is an actual established time frame for proper notification of all key actors. These actors must be notified, including their legal representation, usually within a matter of days. So, for example, if an officer is under investigation, he will or she will be notified as well as a series of whoever else is identified in the agreement within that municipality or within the city. Often, too, the chief will also be notified. Whether the chief has a say in whether the investigation will carry forward can depend, which is why this is not in every scenario, especially when it comes to citizen filed complaints. Next, what will happen is the investigation phase. The BM has the right to have provided legal representation and FOP or the police union representatives. And then what happens is those parties are then given the documents of the actual complaint. What's important about this is that the information they're given can often actually be the citizen's name, the details of when they were arrested, and all of this, and this will come into play later. Then the BM will eventually be called to respond to the allegations. And this is very important because this is their time to actually speak. And what's very important as well is that during this phase there are protection mechanisms for the police officer, which of course would be very important for anyone who's under investigation. And these can all differ, but some of the indicators that were quite common were protection factors of the officer, or anything that would warrant no unethical investigation action. So for example, the name of the officer could not be shared publicly or his or her picture. As well, no unethical investigation steps such as abuse, very long interrogations without proper representation. Actually, many interrogations have to happen within day shifts. And again, the rights of the actual officer have to follow or adhere to the actual union contract. If that doesn't happen, this can all fall apart. Next, you have the procedures, and this goes into the conviction. In order for the investigation to move into the conviction phase, 2 more conditions to proceed must be met. And that is that the procedures or protocols are all followed with no violations. Any violations can really result in the case falling apart. While the BM will be called to respond to the allegations, the ex post may completely fall apart, as well as the conviction. They may have a reprimand on their record, but nothing more. There will actually be no disciplinary action that can be filed. Likewise, there is the condition to proceed must be met if the investigation phase is actually completed within an agreed time frame allotted. And this often seems to be within a series of months. And for example, 6 months. There was a large variety or range in which this investigation phase was allowed. Also, no union contracts actually talked about who was the entity that would conduct the investigation. This will be a question that's emphasized later in some of the PowerPoints. In the conviction phase, if both these conditions are met, you may proceed into the conviction, in which the investigation will lead to either a conviction, and if it does, as highlighted by the green, you're proceeding because there was actual cause to proceed, then there are a series of events that can happen. Often in this scenario, which is quite clean, the disciplinary action will either be a reprimand, which eventually will be expunged. Reprimands and suspensions often have an opportunity cost or a transaction cost that affects the officer. And this includes salary docking, vacation day dockings, or being suspended from actual work, which includes pay. However, if it's just a one-time offense, or maybe a second, eventually the records will be expunged, often within a few years. this is the conditions that have to be met for those records to actually be kept, and for the officer to face something more than just maybe a 7 to 10 day suspension. For them to be dismissed or legally convicted of a crime, often there needs to be a repeated offense or so grave as a crime that it can go to court. And this includes the number of convictions or convicted complaints, the number of convicted complaints over a certain number of years. And some examples that are highlighted that seemed quite common were, for example, 2 convicted complaints, physical control complaints, or drug-related offenses within a 1 to 3 year period. Or if an officer is promoted, often those complaints do not follow on to their new record, and they will be expunged. However, if these measures are actually met, what will happen is, instead of just simple disciplinary action, it will actually go to repeated offenses. Repeated offenses can still lead to suspension and eventual expunging. However, in most cases, if they are severe enough, they will lead to dismissal or legal conviction, which will mean that they cannot be expunged at any time. These become permanent records and public records, often in many cases, depending on specific requirements that are legally decided by judges. There can also just be no disciplinary action. Instead of a reprimand or a suspension, there is just the fact that it's let go. And this has been known to happen, especially when there's just not enough evidence to fully convict. It may be put onto their record, but again, eventually it will be expunged. At any point, if there is actual disciplinary action, the BM may appeal the rulings. And actually, one of the huge indicators is the number of appeals allowed. In some union contracts, there are rules and options for someone to appeal through the union 5 to 7 different times based on 5 to 7 different cases. And this really can hold up the entire investigation. This means that the city has to go back, investigate, and this can mean a lot of money. And on top of this, we don't realize that if the ruling is upheld, that's a positive thing if the officer had actually violated the tenets or unethically had done something on duty. However, if not, the compensation and the cost to the city can be a huge reason why investigations are not fully pursued. In slide 2, we examine what happens when the conditions are no and they actually